Good. Welcome. Welcome to the 7th event of the speaker series, Social Policy Unpacked, Exploring Pathways for Green and Digital Transitions. It's a series co-organized by the Directorate-General for Employment, Social Affairs and Inclusion and the ZOE Institute for Future Fit Economies. It is funded under the Horizon Europe program. My name is Christoph Gran. I'm the co-founder of the ZOE Institute. It's a think and do tank working at the interface of science and policy, and we're specialized on new economic thinking and co-creation of new policies, I would say. Before we come to today's speakers, Professor Karen Yeung, let me quickly introduce the series. We want to invite you, the public, policymakers, whoever is here today, to think outside the box and let yourself inspire with new ideas to make sure that the transformation we are in, that the Green Deal, is fair and just, that we make it to live within planetary boundaries and all of us in a good way, I would say. The series consists of 12 online seminars running from December 22 until June 23. And after today's event, the next one will be on 12th of May at 2 p.m., which is the perfect opener for the Beyond Growth conference that takes place the week after in the European Parliament with Professor Julia Steinberger on social policy in a post-growth world or post-growth deal, which is a very interesting project they have. There will be more events. You can inform yourself on LinkedIn and Twitter. We will advertise them. And for more details, you can see the homepage. It's in the chat, the link. And of course, we will share the recordings of each event. The event is structured as follows. We have roughly 30 minutes with Professor Yeung. She will present her ideas, and afterwards we will have a Q&A session of roughly 15 minutes, together with Mihai Palimariciuk from DG EMPL. We will start collecting the questions in the chat, not only in the chat, but also on Slido, of course. There's a QR link you can use. Put your questions there. We will collect them and post them after the intervention. Of course, you can use thumbs up to make sure the questions you like most will be asked afterwards. But now over to Karen. I mean, algorithms and big data are a very big part of our daily lives. I guess everybody has a mobile phone here, at least. So if you did not see The Social Dilemma, at least you encountered ChatGPT in the last weeks or month, or had some connection with artificial intelligence. And in order for the digital transition to be a fair one, it is very important to consider the rise in risks of these technologies, their ethics when used by government and in public administration, and the need to urgently translate constitutional principles into action through a clear-sighted recognition of the values at threat. Let us welcome Professor Karen Yeung to share her expertise on these issues. She's Interdisciplinary Professorial Fellow in Law and Ethics and Informatics at the University of Birmingham. Her research is at the forefront of understanding these challenges associated with the regulation and governance of emerging technologies, as well as their legal, ethical, social, and democratic implications. She frequently works at the intersection of research and policy, including as a member of the EU high-level expert group on AI. Karen, I'm thrilled to have you here, and I'm very much looking forward to your intervention. Please, the stage is yours.
Thank you. I'm glad that I managed to actually get on the Zoom call. It's a particular pleasure for me because, as was mentioned just now, I was a former member of the EU high-level expert group on AI. And prior to the tragedy of Brexit, I was really heavily involved in European discussions and policymaking about the governance of digital technology. But sadly, not anymore, through no fault of my own. So I'm glad that you still welcome me back to share my ideas and that they remain relevant to you and the work that you are doing. So as has already been mentioned, the focus of my research in the last 15 years or so has been on the regulation and governance of emerging technology. And in the last 10 years or so, with a focus on the implications of a suite of technologies associated with automation and the so-called computational turn including the rise of big data analytics and artificial intelligence. And so that's the ongoing focus of my research at the moment. And it's a pleasure for me to share with you some of my research insights today. So there are many things I could talk about, but one of my particular pet subjects is the use of digital automation in the public sector. And as I'm sure you are aware, for many decades now, European governments have actively pursued a digital transformation agenda within public service delivery, attracted by the promise of faster, better, cheaper, more efficient decision-making and cost control, especially under the pressures of austerity. As many of you will know, that the digitization of the public sector is a central plank of the EU's digital agenda, and it's been given a little bit of a steroidal injection in 2021 from the Commission's coordinated plan on AI, which aims to make the public sector a trailblazer for using AI. So there's nothing unequivocal in that statement. And I've looked at these systems now for a couple of years through a number of projects, and I've come up with the term new public analytics to denote a wide variety of public sector reform projects and programs that all involve the take-up of digital automation, of algorithmic decision-making and data-driven technologies in public administration and public service delivery across many countries, not just in Europe, but beyond, from around about 2010 onwards. For those of you that have any background in the study of public administration, I use that term deliberately to pick up continuity and discontinuity with the new public management, which were a series of reform proposals and projects spread throughout the world under the Thatcher and Reagan era, powered by a belief in the superiority of markets. So it's the new public and analytics that I want to talk about today. And for some reason, I can't get my slides to move. So just excuse me while I work out how to do that. There we go. So there are many reasons why these are attractive propositions for public managers, because these systems display a wide range of desirable properties, particularly automation, scale, remoteness, and their capacity to generate behavioral predictions about anything that moves, whether that's people or something else. And of course, public managers are keen to replicate the commercial success of these technologies because they have really been transformative in that domain. But there's a problem. Something is lost in translation, and indeed many things are lost in translation. And the problem is that when these systems are moved into the public sector, they have costs, and in particular, they generate human costs, particularly when they're employed by governments to deliver public services and functions, and they have in fact devastated thousands of lives. I'm sure you're familiar with some of these very well publicized examples, but just to spend a couple of minutes just recapping, because I think it's useful to remind ourselves that these are real systems that affect real people's lives. Perhaps the most well-known and arguably the most scandalous, although I think the UK Postmasters Horizon scandal competes with the Dutch child benefit scandal for the most devastating. In terms of the Dutch child benefit scandal, it ultimately led, as many of you will know, to the resignation of the Dutch government in 2021. It involved the use of an algorithmic system which had self-learning elements. I'm not quite sure what that means, but it sounds like machine learning, which Dutch tax authorities began to use in 2013 in order to help identify benefit fraud. So the system worked by automating the creation of risk profiles for individuals, but the system itself was a black box system. And by this, I mean that the inputs and the outputs of the system can be viewed, but the internal workings of the system could not. And so effectively, this system operated without any meaningful human oversight. At the same time, the system was configured in an exceptionally harsh manner so that individuals who acted in good faith but made little mistakes in their completion of payments or submission of details or made incomplete payments were accused of fraud. And that triggered a very severe penalty in which all of the receipts that they had been paid under the program then had to be repaid. As a result of these extortionate debts, thousands of parents and caregivers, mostly from low-income families, were falsely accused of fraud, and this disproportionately affected ethnic minorities. Several victims committed suicide, and more than 1,000 children were taken into foster care because their parents could not afford to care for them. In May 2022, the Dutch government publicly admitted for the first time that institutional racism within the Tax and Customs Administration was the root cause of the system and the scandal. So there are some lessons there, and the costs were massive. Equally devastating, or arguably so, was the UK Postmasters Horizon scandal, which you might be less familiar with on the continent. This concerned no machine learning. It was just an ordinary financial reporting and inventory management software that had been used by the post office. And it was to be utilized by all these little postmasters who operate these kind of mini post offices throughout the country, operated by very ordinary people in local communities. It turns out that the system was deeply flawed and extremely buggy and very unreliable. And Fujitsu and the post office knew about this, but continued to deny it for years. As a result, many, many hundreds of honest, decent people were criminalized, several of whom went to jail with devastating consequences for them. And there were also a number of suicides. The story is not over, and these people are continuing their fight for justice through a parliamentary inquiry. And thirdly, you might be familiar with the Australian Tax Office scandal, or the robo-debt scandal. In this example, the Australian Tax Office began using an automated data matching system to identify whether individuals were receiving the correct amount of tax and benefits back in 2016. But because of a mismatch in the underlying assumptions in which these calculations were made, and the way in which individuals actually earned income and received payments over time, the result was that almost 500,000 people were served with unlawful debt notices demanding repayment of overpaid benefits, including people with disabilities, mental illness, and many of whom were desperately poor, resulting in at least 3 reported suicides. So we see then that it's not like recommending you a book or a pair of slippers. These are serious systems with serious consequences, and we see that governments throughout Europe are already adopting them based on what I consider to be promises without proof and without regard to their capacity to automate and to scale mistakes and injustice, and therefore the abuse of power. The problem is that these adverse impacts appear to be largely invisible to those in power and those who configure them, partly because it's largely the poor, the marginalized, and the vulnerable who are processed by these systems, and they lack significant political clout. So some of my recent research, particularly research funded by the VW Foundation in Germany with a number of German colleagues, has looked at 3 of these systems used in the criminal justice context throughout Europe. Only one of them remains still in use, but 2 of them were in fact in use recently. And these 3 systems, which are listed in the slide, all purport to assess different kinds of riskiness associated with individuals, otherwise known as citizen scoring systems, in order to inform decisions about how those individuals should be treated. And the kinds of decisions that they seek to inform were rather different, but they're all sort of variations on a theme. So, for example, they've been used in London to inform decisions by the London Metropolitan Police about who to stop and search. So, in particular, the London Gangs Matrix, which is still in use and available on the mobile phones of London police officers, is a dynamic digital dashboard and a database which lists individuals, including children, I hasten to add, identified as potentially at risk of involvement in gang violence, so-called gang nominals. And it also produces an algorithmically assessed harm score, and individuals are graded as red, high risk, amber, medium risk, or green, no or negligible risk. Interestingly, it also contains information about potential victims of gang violence, but they are not given a score. Another set of decisions that are influenced by these systems are decisions about whether to divert a person away from the formal criminal justice process, particularly those who have been arrested, and instead to divert them into a rehabilitation program rather than charging them with a criminal offence. And a tool of this kind was used by the Durham police until recently in the UK, the so-called HART, Recidivism Risk Assessment Tool, in order to inform decisions by custody officers once a person who's been arrested is taken into the police station, whether or not this person should be offered an opportunity to participate in the checkpoint rehabilitation program. And then, of course, there's the Dutch ZOE welfare fraud predictor. Again, you may be familiar with this one, which was a welfare fraud prediction tool, which trawled through data from multiple administrative data sources, including utility bill data, for example, again, to profile individuals to find irregularities and therefore flag high-risk candidates for further criminal investigation. So all of these systems have been used. Two of them have stopped, as I've mentioned, but one of them is still in use. And you can see that they are being used to make pretty serious decisions, but the way in which they operate is opaque, remote, largely impervious for interrogation by those who encounter them. So, for example, we have no idea what goes into the harm score of a child who has been ranked in the London Gangs Matrix. That information has not been made available publicly. We don't even know if the if the risk predictions are used based on a machine learning algorithm or not. That data is simply not available. One of the problems with these systems is that normative value-based decisions are made inside the hard wiring of the systems themselves. But those decisions are disguised within the bowels of the system. And in doing so, it means that those who preside over these systems, the controllers of these systems, are thereby given a wonderful opportunity to offload the costs and the burdens associated with using these systems, including errors and the transgression of rights, onto other people. And this, at least for me, is especially worrying in criminal justice contexts and other so-called rights critical domains, because they are high stakes. And they're high stakes not because public safety and security is at risk, but because they threaten the fundamental rights of affected individuals. And so essentially what I'm saying is that these systems have the capacity to distribute and redistribute benefits and burdens by shifting the costs and the burdens of mistakes onto the shoulders of other people without their consent or consultation. And this is particularly troubling because these systems are, understandably perhaps, configured to optimize the interests of the controller of the system, often at the expense of the individuals whose data is processed by these machines. And that further magnifies the asymmetry in power and position between the state and the individual. So the way in which my research has proceeded is to examine the operation of these systems and the way that they've been designed through the lens of constitutionalism. And just to allow me to say a few words about that for those of you who are not trained lawyers. Constitutionalism basically is the basic principle on which constitutional democratic states are designed, or at least their governance systems are designed. And it's this commitment that reflects a recognition that the power of the state, particularly the coercive power of criminal justice officials, is very serious and needs to be handled with great care because it's vulnerable to abuse. And for that reason, we need to build into our governance structures institutional mechanisms as safeguards against the abuse of power, against the arbitrary exercise of power, and against the risk of despotism, that is the exercise of governmental power on the whim of the power-wielding despot. In constitutional democracies, the acts of those invested with governmental authority must be open to public scrutiny, and they are, unlike the exercise of power by private parties, constrained by constitutional safeguards, including a number of public law principles. And those principles are intended to act as guardrails and in turn ground more specific legal duties which public authorities must comply with in exercising their discretionary power. So when it comes to these new public analytic systems, a number of other legal scholars have highlighted the dangers that these systems pose to so-called rule of law values, values that will be familiar to you, values of transparency, fairness, and accountability in particular. And while that's all well and good, it doesn't go far enough. It's one thing to say that we care about these principles, but for me, what we really need to do is to make them real. The challenge remains in operationalizing these principles rather than simply espousing them, and to demonstrate that our systems operate in accordance with them in real world contexts. And so that's what my research investigations have sought to do precisely that by examining the intersection between constitutional principles and the technical choices made by developers in building and configuring these systems. And I suppose the core take-home message that I want to share with you from my research is that these technical design choices, which may appear fairly boring and mundane from a technical perspective, may well violate basic constitutional principles, including the rule of law, because they may involve unlawful violations of legal rules or otherwise be ultra vires beyond the legal authority of the public administrator. They may entail a violation, an unjust violation of human rights, such as the disproportionate interference with rights to privacy and data protection. And in particular, many of them entail violations of the right to due process, including basic rights to notice, to a fair hearing, and to contest the decisions. So I want to say a little bit more about this core piece in order to illustrate what I mean when I say that technical design choices can be constitutionally problematic. So there are these three systems that I've already highlighted: the London Gangs Matrix, the series system used in the Netherlands, and the HEART tool. And what I did in this research piece is try and find as much publicly available information about these systems that I could, and to look at the design choices that are made in their configuration and operation and test them against these core constitutional principles. And in doing that, I divided the design process, if you're designing and developing an algorithmic decision tool, into 4 different stages. And what I found is that at each stage of this development process, choices are made that have constitutional implications that are being overlooked or ignored in their development. So let me begin first with the training data. So as some of you might know, in criminal justice, algorithmic models to produce risk assessment predictions about individuals are typically trained on historic data, but this data is often highly misleading. So to give an example, particularly in the US, much less so in Europe, the use of recidivism risk predictors has become commonplace. So they purport to offer a prediction of the likelihood that a particular person will engage in serious violent crime in the next 2 years or so. The problem is that if we were to build a crime risk predictor, then we would have to have a comprehensive data set about crime that has been committed in our jurisdiction. But of course, we know that we simply don't have that data for a number of reasons, because crimes get committed and are not reported. Crimes are committed that we're unaware of. And therefore, we simply don't have a comprehensive crime data set. But that hasn't stopped criminal justice authorities from building risk predictors for crime based on arrest data instead. And hopefully all of you recognize that arrest is not a reliable indicator of whether or not a crime has been committed, because a person arrested may be completely innocent. An arrested person may not be charged. Arrested person may be charged but not convicted, and many crimes may be committed for which no arrests are made. So that means that arrest data is a completely unreliable indicator of crimes committed, but that has not prevented the use of arrest data from being used as the basis to build algorithmic models to predict whether an individual committed crime. And this is in fact what the HEART tool does in order to predict recidivism risk. So it's questionable whether that's lawful. For if the legislative regime says that the custody officer must make an assessment of the likelihood of that person to commit a crime, it's questionable whether it's lawful to rely on predictions about whether a person will be rearrested, because that's really what the tool is generating. Not a prediction about crime, but simply a prediction about rearrest. Then another question, or many questions of considerable importance, are choices that are made when you actually build the algorithmic predictor itself. And one of these that's very important, and this is particularly the case, for example, in health diagnostics, is how you configure your error thresholds. And as you know, predictions that are made through machine learning tools are inherently probabilistic. So errors are inevitable. And here, by convention, errors are defined in a very narrow and technical sense as the failure of the model to generate an accurate prediction on unseen data from your initial historic bag of data, and the errors may be either false positives or false negatives. Again, if we look at the HEART tool, and the reason why this one was useful is because the former head of the Durham Police Force actually wrote her master's thesis about the tool, and then she published it online. And so we could find more information about these design choices, which aren't typically available. Unfortunately, she's taken the thesis down, but it was once publicly available, and lots of researchers actually gleaned information from that publicly available master's thesis. But anyway, the point of that being that in her master's thesis, she says it is a much more serious error to make a mistake and predict that a person is harmless when they're in fact harmful, rather than to predict a person being harmful when in fact they are harmless. And the answer to that, of course, is, well, it depends upon who you ask. So while the public might think that's true, I'm sure that the innocent person who is predicted as being harmful does not take the same view. But more importantly, from a constitutional perspective, one of the most fundamental rights we have is the right to the presumption of innocence. And the corollary of that is a right to be presumed harmless, unless, of course, you have been convicted. Then we can have another discussion. But if you have not committed a crime, you have a right to be presumed innocent. It is a constitutional right. And these rights must be configured into the error thresholds of these tools. That does not appear to be happening. And I think because technical developers have no idea that that's what the law requires. So already I hope that you're thinking, there's a bit of a problem here. We're not paying serious attention to the legal constraints that should be informing the design choices that are made when we build these kinds of models. Further questions arise when you test for the quality of these models. And here a number of quality criteria are available. One of the problems that we currently have is that this is still a Wild West. And although accuracy is still the primary quality criteria that's used, these are defined by convention rather than law, and there are no strict standards about how accuracy judgments are made. In any event, the way in which they're conventionally undertaken in data science is fairly problematic when we're making predictions about people's future behavior that may result in them being deprived of their basic liberties. At the same time, we're building predictors that are being used based on machine learning algorithms that basically try and find patterns in data sets. But what we don't know, of course, is whether those patterns actually reflect anything meaningful in the real world. This is the problem of spurious correlations, and the correlations may be found by the algorithm, but they may be, to use the technical term, complete bullshit. In other words, they don't reflect any real world relationships, and yet we might be blithely using them as a basis for making predictions about people. We don't have any law against it. We don't have any specific filter against that happening. We, in fact, don't even know the conditions upon which it's legitimate to use these kinds of predictors. That is a yawning gap in the way that we are thinking about and producing these models across the board. It's one thing to predict your shopping interests. It's another thing to be making decisions about your life. We should be paying much more attention to this problem. And finally, and perhaps most familiarly, choices are made about how we design the interfaces that are provided to frontline users. And of course, there's an understandable tendency by the designers to build these for convenience and efficiency. We love seamless, easy to use apps, as do frontline bureaucrats. The problem is that these interfaces are being built in ignorance of basic rights to ensure due process and rights to appeal and give reasons to those who are affected by them. And it was not clear at all in my evaluation of these tools that there was any systematic awareness for those requirements to be built into the interface design when the outputs were being delivered to frontline officials. It seems to me then, in short, that all of these constitutional principles that I've been talking about, when the technical choices are being made to build these tools, are either being overlooked or ignored, or perhaps they're simply unaware that they exist at all. And this seriously enhances the dangers that they will involve produce injustice and certainly the unlawful exercise of public authority. So what should we be doing? Well, I guess if you start from first principles, then the basic principle is that if you exercise governmental authority, then you need to exercise it demonstrably in accordance with constitutional principles. This isn't happening. Why isn't it happening? I'm not sure why it's happening. I suspect that it's because of a prevailing and false belief that we're not doing anything particularly new in automating these systems and moving from an analog world. We're just doing what we've always done. We've always had to try and identify welfare fraudsters. We've always had to decide who is entitled to welfare benefits. We're just doing it faster, more efficiently, and more quickly through the use of these systems. In other words, business as usual, nothing to see here, nothing for you to worry about, failing to recognize that in fact these systems have the capacity to redistribute burdens and benefits without any consultation, consent, or even transparency. And the result is the accentuation of the possibility of injustice and the abuse of power. So in my view, there is an urgent need for us to demand that these systems are developed and configured in a manner that is demonstrably in compliance with constitutional and legal principles, and that public authorities must demonstrate this to an appropriate authority before they are deployed, certainly in rights critical contexts. That is not currently happening. In my view, this should be a red line. Unless these algorithmic decision support tools being used by governments to inform rights critical decisions are in fact configured and implemented in a manner that is demonstrably in compliance with public law principles and doctrine, including respect for human rights, then we shouldn't be using them. That's my take-home message. There are some references where I've published on this, and I do have a handout, which I think, or I hope, Lily will distribute so that you can download it. That's it from me. I am open to questions. Thank you.
Thank you very much, Karen.
You're welcome. Let me see.
Too interesting and too scary. And yeah.
Yeah, sorry about that.
Thanks,
but you know, I'm
made
made to pay attention.
Okay. No, seriously, very interesting and scary topic you have here. And I think I'll hand it over to Mihai to ask you some of the questions we collected. I think you're muted.
How about now? Better?
Perfect. Yes.
I was double muted. Something you learn new every day. Thank you, Karen. Very, very interesting presentation. And thank you, Christoph, for the introduction. Before I start, I just want to perhaps invite the participants to go to Slido. They can ask questions there and they can upvote different questions. I will read them. You can also use the chat, but I see there is nothing there yet, so I would encourage you to just go to Slido. And with that, perhaps I would like to ask something which is perhaps all of us at the Commission are thinking about it already, and that is our legal framework. So one of the questions that was asked by Yasmin, I see on the Slido is the EU legal framework, including the proposed AI Act, sufficient to meet the challenges that you have described?
The short answer is I don't think so. For a number of reasons. I think that, well, there are two primary reasons. Well, three, actually. In fact, I could find many more. Firstly, the arbitrary way in which high-risk systems are defined, rather based on a list approach rather than on principle. That means we will see new systems that are built in order to avoid the list, that generate high risks for rights and for safety that are not covered. So there's a scoping question. Secondly, there is a standards question. So one of the things that the AI Act purports to do is to claim that the risks that must be evaluated are risks to safety and risk to rights, but then it gives no guidance about what that means. And so the task of fleshing out what that means are basically being delegated to technical standard setting bodies. And questions about rights violations are not really ones that engineers are very well equipped currently to identify and articulate in the form of technical standards, whether or not they can in fact be subject to technical standards at all. These are judgments that need to be made, difficult legal judgments that need to be made. And I am concerned that what we will see is a proliferation of technical standards which claim to demonstrate respect for rights, but do nothing of the sort, but job done. I've self-assessed, it's all compliant, Bob's your uncle, off you go. I don't think that's very protective. I don't think it's enough. I'm really disappointed in the level of rights protection that has been hardwired into the regime. And maybe over time, we will have a better way of understanding what that means, but I am rather skeptical of the capacity of technical standards to cater for the risks to fundamental rights and the social foundation of democracy. Sorry, that's a very negative answer, but you asked, so there you are.
No, thank you very much. And I think that we do need to hear some negative opinions as well. Maybe I can, on the basis of your answer and to hear that our legal framework perhaps is not still well equipped, and together with all of the risks that you told, one question here asks, okay, with all of that in mind, is there one area where AI should not be used in public administration?
Gosh, I mean, how long have you got? So, for example, I think there should be a presumption that we do not use these for rights critical decisions. Yeah, I really don't think we should be making these nonsense assessments about people's recidivism risk based on troves of administrative data that we haven't established as a matter of scientific evidence bear any relationship to people's propensity for violence or not. I mean, we wouldn't do that for pharmaceuticals. Why are we doing that for the treatment of people? It doesn't make any sense to me. You know, we have a very, and the only reason we have it for pharmaceuticals is that we have the thalidomide tragedy and 40,000 babies were deformed or died. And we learned that actually this is not okay. We need to have more scrutiny of the way in which we release these highly risky but potentially enormously beneficial technologies into the world. And we've done so reasonably successfully. And COVID showed that we were capable of getting those systems to work quickly when we needed to. We're not doing anything like that for AI. In fact, we have the opposite presumption. It's presumed to be fine unless it creates problems. And when it does, we'll worry about it then. And even then, we really won't know what to do about it. So I think there's a completely cultural reversion based on a kind of move fast and break things mentality that we really need to pay attention to and think, hang on a minute, this is really problematic. And we really need to get a grip on the reality of the wrongs and the harms that can be generated at scale as a result of these systems. Not that they are potentially beneficial, they are, but the power of these systems is double-edged. And we're not paying enough attention to one side of that power.
Thank you for the answer. I think then perhaps would be, I see there are 2 or 3 people that asked the reverse of this question of these are the areas where you believe that the risk is too great, so we should not use it. Is there a place where the AI can actually benefit and we should use it there?
Yeah, so one of the things that machine learning tools are brilliant at is pattern finding. So for example, there are huge possibilities for using it to do an analysis of new chemicals and chemical risk. You know, this is not rights critical, it's safety critical. You can use these systems instead of using animal testing and models and using a substantial equivalence test. We could pass them and do chemical analysis in a much more powerful manner and to evaluate environmental safety threats on that basis. So there's plenty of scope for using these tools to find patterns that are potentially dangerous and to act upon them. I don't understand why we're focusing so much on people. Why don't we focus on unsafe things? There's so much scope to be using them there. And I'd like to see more of that. Maybe it's because you can't monetize that in the same way, whereas you can monetize people. I don't know the answer to that, but it troubles me. I think there's huge scope to using it because it's a powerful tool for generating new knowledge. We just need to find the right domains in which that knowledge can be harnessed in a valuable and welfare enhancing way.
Thank you. I'm just going to take advantage to ask one question, which is very interesting for our unit because we are also working on Horizon Europe. So one of the question is, how could we further take advantage of the research and existing funds to further analyze and understand these technologies? So here, basically, if you have an abstract that you've tried to push, or if you have an idea, please do let us know.
Sure. So actually, just on that, I am the beneficiary of one of the Horizon programs, although sadly due to Brexit, UCRI is paying for my research component. One of the things that does frustrate me about the Horizon program is there's so much investment in the technical dimensions, and we aren't investing more seriously in really thinking about the social implications of these technologies. So I am one lawyer amongst 40 computer scientists, and they all say, what should we do, Karen? So I just think there needs to be more investment in social science and humanities research to work out how we deal with these problems, not just at the technical end. And the technical people need to work together with the social science researchers to really get a grip on the challenges. And that's really hard to do because we speak different languages, we have different worldviews, but we need to take it seriously. We need to do the hard work necessary to understand each other and to come up with new institutions that can address these challenges that will genuinely unleash the power and promise of AI without all the negative stuff that at the moment is simply being spewed out without sufficient constraint.
Thank you. Now I see that there's a lot of questions that are being gathered on the poll. Christoph, I don't know how many. I believe that we have some more time.
We have 10 minutes plus a little bit left, 12 minutes, easy.
Perfect, super. Then let me go through some of these questions. Maybe I can manage to group them as well. But one that I see that has been upvoted, so there is some interest, is if you can give us some example of transparent and participatory algorithmic tools that have been used, especially perhaps in government.
Oh gosh. Okay. There is one very promising report from some Stanford researchers looking at some of the systems used by federal agencies in the US, like the Securities and Exchange Commission. And so they're in those kinds of financial contexts where we have huge troves of financial data to find patterns in the data. So for example, credit cards do a brilliant job of filtering out potential fraud. You know, one weird transaction, my credit card gets stopped, they work very well. So in the financial domain, actually, there's quite a lot of scope for using pattern recognition to find suspicious transactions, for example. And it's appropriate that we don't know exactly how those algorithms work, so that although we still need to be assured that they work well, because they're looking for transactional problems or dangers. Whereas I think once you start looking at routinely collected administrative data from local authorities. You're talking about entirely different kinds of data, where in fact, we're not even talking big data. We're talking administrative data. We're talking tens of thousands of data points. That's not really big data. And we shouldn't be certainly making decisions about whether or not a child is vulnerable based on that kind of data. That's just nonsense, frankly, at least in my view.
Thank you. I see one interesting question also is in regards to qualifications and with skills. So the question goes as this: is there a need to define the skill qualifications for AI and the applications? And are there evidence of AI professionals in the public and private sector? And I would just attach to this perhaps this question of, is there a need for a different kind of qualifications specifically for the public sector?
Well, that's a really good question. I mean, I'm inclined to say yes, but I think it's more having systems in place to make sure that we don't unleash systems that can do this kind of harm. One of the things that I have found is really difficult is trying to get that cross-disciplinary conversation happening. So understandably, I just can't expect technical developers to have a full understanding of constitutional principles. It's just not meaningful and it's not fair. I mean, trying to understand data protection law is a challenge in and of itself, right? So what I think we need is effective cross-disciplinary teams and systems to work together in order to make sure that the right guardrails in place. So I think it's just not practically feasible to expect that experts will have the full range of expertise that's necessary to put the right safeguards in place. And so we need to work a bit like, NASA teams trying to get a rocket to the moon, it's just, we have to think of it in those terms. And then if we're really having appropriate care thresholds and we're aware of the dangers, then we can move forward with more confidence on a more trustworthy basis. At the moment, it's still too much of a Wild West. And part of that problem, I think, is quite rightly highlighted that you don't need a special qualification to call yourself a data scientist. And there's a kind of culture of learning by doing. It's very bottom up, and it's so interesting. So we've started a cross-disciplinary degree course at the University of Birmingham where we take lawyers and we teach them one semester of data science. And the two conversations just don't have to speak to each other. So this is the serious, I think it's a really, really major challenge to fill that competence gap and to have those conversations so that we can actually understand what kinds of machines we're building, because I just don't think we really do. I think there's a kind of taste it and see mentality, move fast and break things, just put it out there, which really, we really need to turn that around. It's just not viable anymore, even if it ever was.
If I can deviate just a second from the poll and to circle back on this, because there has been this LinkedIn study, I believe, with the differences of AI specialists in Europe and the US.
Right, interesting.
And there was this thing that in the US, AI specialists would go into the labor market much younger, whereas in the EU, you would see that AI specialists have PhDs, so have been working for way longer. So but then my question would be, it's clear that it needs to be AI specializations need to include a bit more on courses on ethics, but can we see a distinguishable, can we see the results of this kind of longer training in Europe? Are AI or are AI or algorithms that are developed in Europe more respectful of constitutional rights, as you call it, or is it only that in Europe you have harder laws that protect? I don't know if you can comment on this, but yeah, probably.
I mean, I could only guess. I have no evidence. One of the things that's noticeable in other domains in which comparative regulatory studies have been undertaken is there's quite a different market-oriented culture in the US. On the other hand, it's very litigious. So these two pressures move in opposite directions in the US. Whereas in Europe, there's they tend to be quite risk averse in relation to impacts on community values. So the GMO debate was a nice example of that. The North America just said, bring it on, you know, we'll eat it. It's great. And the European said, oh, no, thank you, not here. So I do think it sort of depends upon the domain of application. And I think it's very culturally determined. So I'm afraid I don't really have an answer to that.
Not a problem. Perhaps then the most important question, I'll combine two, because one person says AI applications of public governance, can it be reliable if we just don't improve the quality of data gathered at all? And then the final question is how can we not reproduce the biases, and how we make AI that is not discriminatory?
Okay, so the first question about can we improve these systems without improving the training data, is that the question? Have I understood you correctly? Well, I guess you could be a little bit more refined about the kind of quality thresholds that you apply to the same training data. So you could have more demanding thresholds. And in principle, it would be better, but you've still got the same crappy data, right? So that's still a foundational problem. This question about can we remove the bias in historic data? You can, but how would you do that in a way that was non-arbitrary? So, for example, that one study that I like to cite a lot was done by Carnegie Mellon researchers back in 2016, I think, and they had 1,000 users, 500 female, 500 male. They got those user profiles to click on some job recruitment links, and then they wanted to see what ads were automatically served up to these 1,000 users, and they found that female users were 6 times less likely to be showed high-paying job ads. That's because historically women have been paid very poorly, not because women are not interested in high-paying jobs. Let me assure you, they really are. They haven't had them in the past. So how do you eliminate that bias? Well, you just have to make it up based on your real world vision of what the world should look like. You just make up the data. I don't know how else you could do it in a non-arbitrary way. You just have to start with a vision of what you think the world should be doing and then create your simulated data accordingly. I don't know how you would do that. So I'm afraid I don't know. I can't imagine it, but maybe that's just a limitation of my imagination.
Okay, thank you very much. Christoph, I'm looking at you. If I have time, I can ask one more question. If not, I'll hand it over for you for closing remarks.
No, go ahead. Let's ask the last and final question with the answer that brings everything to the point in one sentence.
Right. The last question that I would like to ask perhaps is the use of AI in citizens panels and juries in providing advice, but leaving the conclusions to humans. To neatly just put some ideas together on some hopeful uses, but also some human jurisdictions. So do you have any quarrels with this idea, or do you think that it is a good use of it?
Well, I am all for the need to have much more active participation from ordinary people in the choices that we're making about our technological infrastructure and applications. But people have been wringing their hands about this question for the last 30 years, and we still haven't worked out how to do it. So this is the challenge, is how do we democratize collective choices about our public technological goods and infrastructure? I wish I knew. I really think that's a big challenge. I suspect we'll need new institutions. I don't know what they look like, but they don't look like what we have now, because I don't think it's really working very well to do that task.
Yes, and maybe it also needs some motivation to include citizen panels and their ideas into policy making. And then you ask, how can AI support this? So maybe that's not the problem here. The main problem. I don't know. Anyways, Thanks a lot for
You're
this
very welcome.
super interesting dialogue, also the questions and everything, and,
Thank
all
you.
your answers. Very interesting, and I'm sure there will be some follow-up questions, and I'm looking forward also to the script you made, or the two-pager with some ideas. We will send it to every participant. And thanks everybody for being here today. Thanks, Karen.
You're very welcome.